Can I get sole custody of my kids? Now, maybe, but probably not. Here's the thing, I think this question assumes a fact that's a common myth, at least in Texas, when it comes to custody and possession. People will say, I want sole custody, when what they really mean is, I want primary custody. Because let me explain. Sole custody is where you have exclusive decision-making rights when it comes to your children's health care, medical, dental, school, psychological decisions. Like, you have all of those rights to make all of those decisions, usually some sort of increased possession of the child, and the other parent doesn't have the right to make those decisions and has some sort of lesser, more restrictive possession schedule. And where such a disparity will occur usually involves some pretty bad facts, like think drugs, sex, and rock and roll kind of stuff, right? Where there's a person with an ongoing substance abuse issue who maybe hasn't gotten the help that they need to get yet and who isn't on a recovery situation. They're not like already sober for a couple years, like maybe in that situation. Domestic violence, okay, yes, that's a situation where it can occur, things like that. But your more, typical custody situations where like, well, I'm the mom and I've stayed home with the kids and I do absolutely everything for them. That's not going to get you sole custody. It may get you primary custody where you have the kids more of the time and you have the right to receive child support payments, but it's probably not going to get you sole custody unless for some reason the other parent agreed to that. Because so long as the other parent is a reasonable, functioning adult who can parent the children like fine, and there's no big, huge red flags, and I'm not talking like your own senses about the red flags, but like bad stuff, probably one of y'all is going to be the primary conservator and one of y'all is going to be the not primary conservator, because there's this part in the Texas Family Code, a presumption that parents are joint managing conservators of the children of the marriage, okay? That means you both have equal rights to make decisions about the kids, even if the possession rights are different. And so even if you have the kids more of the time, you may still be, and likely are, joint managing conservators together over these kids. So it's pretty unlikely, absent some exigent, like important, kind of urgent, acute circumstances, that you would get sole custody of the kids in Texas. Not impossible, but you really need to talk to a lawyer. That's not going to just happen on its own. You're going to need a law firm to help you think through whether you have enough to ask for sole custody and whether it's possible, like you may get it on a temporary basis while the divorce is ongoing. But if the other person cleans up their acts or kind of gets it together at the end of the day, it's probably going to be something more typical with someone has primary and the other person has an expanded standard possession order, which we've talked about that in other videos, where they have them the first, third, fifth weekend and all of that. So I don't want you to get your heart set and really stuck on these labels. And I also want to make sure you understand what you're actually asking when you ask about sole custody. One common misconception in the divorce and custody world is about joint custody. So people say, oh, we have joint custody. We have the kids 50-50 on a possession schedule. So what they're actually referring to is this equal possession schedule, and they use the word joint for shorthand. Like this happens all the time at schools and things like that, where people they don't deal with this every day. They don't make a bunch of social media videos, right? So this is not top of their mind, but they're like, oh, they have joint custody. And they say that to mean what they're really referring to is 50-50 time with the kids, like week on, week off, or some version of that schedule. But what really I think they're referring to is this presumption in the Texas Family Code. It's presumed to be in the best interest of the children that their parents are named joint managing conservators over the children. And that means they have equal decision-making rights as it concerns health, education, and psychological decisions. Their possession may be different, but if you're talking about joint custody, like technically, probably most people have joint custody, even if one parent has the kids most of the time and one parent has them every other weekend. when you're talking about joint in terms of equal parenting, you're really talking about like we have equal possession time. So not a huge deal, but you just want to understand the nomenclature and the words that you're using. And I think it's helpful to know what those mean, especially if you're going into a lawyer's office and you're like, I want joint custody. And they may be thinking, well, yeah, I mean, you're going to be JMCs, joint managing conservators. But what you really mean is, I want 50-50 possession. So just wanting to make sure you have those terms clear and how they play out in a divorce or family law case.